So what happens if someone registers an existing trademark in another country for a different entity in the same class?
You want me to answer this in the Elmo voice? Just kidding. All right, so what happens if someone registers an existing trademark, so like here in the United States, and they register it in a different country, but it's a different company?
Well, different entity, yeah. So all right, you got Bob Soda or Bob Soda in the U.S. Okay, whatever class that would be under beverages. I want to go and I got an entity in the U.S. that owns it. Now I have a different entity in the U.K. I want to go register Bob's, but I want to sell it as non-beverage. I don't know. It's a weird question.
Or like you have two different companies. It's kind of a confusing question. You can have different countries. What I have here in the United States doesn't apply to you in England, right? From a trademark perspective, trademarks are based on country and the specific use of the product or service in that country. So if someone else registers your trademark in a different country, you're kind of out of luck. Now,
I see. I understand the question. So Bob Soda in the U.S. Exists, existing trademark. I'm in the U.K. I want to launch Bob's with my own company and using that name in the UK. Can I do that?
You can.
There you go. I think that's what they're asking.
You can. Now, of course, like if you're planning on opening a McDonald's, you got to make sure that no one's already registered that in the UK, right, or anything similar to that. And there's other statutory provisions that would prevent someone from registering or using a name like McDonald's, obviously. But yeah, I mean, there's nothing to say that you can't. I mean, it's put it this way: we have lots of clients where we do, our common law unregistered use search, and we find other companies with the same brand, similar products or services in other parts of the world. And we still register and use the trademarks here in the United States.
We'll take it one step further. What's something that Bob's could have done to prevent this other registrant here in the UK from?
Yeah, they could have used the Madrid Protocol to file abroad. So take their application from the United States, take it abroad. There's some cool rights that you get when you do that. You get like priority use dates back in the United States, even though you're abroad, going back to your initial application date. So there's a lot of good statutory reasons why you would want to file abroad from the United States. One of the more interesting ones is like, say in the United States, if you file here in the United States and then you find out someone had filed a similar trademark in the UK, maybe a couple months after you filed in the United States, you can still take your application from the United States within 6 months and have priority of use dates in front of that person who applied in England 3 months after you.
Ooh, that's cool.
3 months before you, right? In the UK. So there's some strategy there, but that's a pretty rare thing to find.
So is it possible to patent an invention or an idea that is similar to one that's already been patented? What's the legal process for doing so? And is it possible to patent? The answer is yes, it is. And there's a couple of things you want to do. It's good if you know that your invention is basically an improvement of, or sort of the next version of an existing patented product. Or a patent attorney can help you do a really thorough patent search of what's available publicly. That's probably the best place to start. You've got a brand new type of opener for a water bottle, and you think this is so much better. You can do it underwater. It's not going to open. It's child-proof. Whatever it is, that new cap. But it really is specific to that one type of bottle that's already been patented. You can get a patent on it, even though you could not actually legally sell the whole bottle with the new cap without getting a permission from the previous patent holder. So you got to kind of understand your market potential might be limited because your idea is similar, or you're not going to be able to sell your product without the base of the patent that's already out there. Now, you can go and approach them once you've gotten your patent rights and say, I'd like to license this to you. I think this is a great improvement. There's a big market opportunity. And you could then make a royalty deal off of every single product that's sold using your new improvement or idea. But again, it's really going to come down to, is that similar differential, between what's already been done and what your invention is it big enough really to warrant the investment of time and money, hiring counsel, waiting that time and building up a business? Is there much sort of, is the ROI looking good or not, is what I would look at. So cool. That'll answer that question. When filing a trademark app, am I allowed to list my DBA as the owner? Are there drawbacks or risks to this? I own a different brand and I don't want to be associated with the new one that I'm creating. Therefore, I do want to list my LLC as the owner of this new trademark because then they'll be linked publicly. I also don't want to create another LLC yet for this new business. So can I simply file a DBA for the name of the new brand and then use that name to be listed as the trademark owner? Also, if I file the DBA with the new brand name, will this be public information that my LLC is operating with multiple DBAs? So the DBA question.
No, you can't. You can't. You can file and list your DBA, you're doing business as, your assumed name, your pseudonym for your business as part of the application, but you still need to list the actual legal entity. Your DBA is not actually a legal entity. It's a stand-in for the name of the business. And so the USPTO is going to require you to list your LLC, or you as an individual owner, or if you have a corporation, the corporation, or your 501c3 nonprofit. So yeah, you'll need to list the LLC. Of course, you could also just file a new LLC and use that name. That would probably be the most appropriate way to do it.
Got it.
I don't think you're going to get around this issue. I think you're going to have to file a new LLC.
And even then, I mean, if someone who's really looking, right, if they figure out the name of the LLC, they can probably go find out from the Secretary of State, the registered agent,
Yep.
perhaps. There are ways to remain anonymous.
There are, and then there's anonymous states too, where you can file anonymous LLCs and corporations. Delaware, Wyoming, Arizona, I think. There's a number of them.
Yeah. How can I patent two businesses that are already in existence if I'm using them as one?
So I think they're asking, like, how can I register two business trademarks if they're using them as one?
Yeah,
So
like basically you started doing, JD's Magic Mo.
Yeah.
Years later, you did JD's Roofing.
Yeah, you can have multiple trademarks owned by the same legal entity, whether it's you or your company can own multiple different trademarks, because you might have one operating company that does multiple things, right? You might have one part of your company might do trademarks and then might do patents. You might want to keep them separate.
Yep.
In which case you might file for two different trademark applications with one owner, but listing multiple different services.